Get ready for the dictation. Start. The Union of India has filed the present application seeking correction of what they claim to be an error in two sentences in para 25 of the judgment delivered by this court on 14/12/2018. This error is stated to be on account of a misrepresentation of some sentences in a note handed over to this court in a sealed cover. The court had asked White Order dated 31/10/2018 to be apprised of the details cost as also any advantage which may have accrued on that account in the procurement of the 36 Rafale fighter jets. The confidential note in the relevant portions stated as under. The government has already shared the pricing details with the CAG. The report of the CAG is examined by the PAC. Only a redacted version of the report is placed before the Parliament and the public domain. It is the submission of the learned Attorney General that the first sentence referred to the sharing of the price details with the CAG, but the second sentence qua the PAC referred to the process and not what had already transpired. However, in the judgment, this portion had been understood as if it was already so done. On hearing learned counsel for the parties, we are of the view that the confusion arose on account of two portions of the paragraph referring to both what had been and what was proposed to be done. Regardless, what we noted was to complete the sequence of facts and was not the rationale of our conclusion. We are thus inclined to accept the prayer and the sentence in para 25 to the following effect. The pricing details have, however, been shared with the Comptroller and Auditor General, and the report of the CAG has been examined by the Public Accounts Committee. Only a redacted portion of the report was placed before the Parliament and is in public domain should be replaced by what we have set out hereinafter. The government has already shared the pricing details with the CAG. The report of the CAG is examined by the PAC in the usual course of business. Only a redacted version of the report is placed before the Parliament and in public domain. The prayer is accordingly allowed. The application stands disposed of. The review portion were listed for hearing in court and elaborate submissions were made by learned counsel for the parties. We may note that insofar as the parliamentary objection raised by the Attorney General is concerned, qua certain documents sought to be produced by the petitioner, that aspect was dealt with by our order dated 10/4/2019 and the said preliminary objection was overruled. We cannot lose sight of the fact that unless there is an error apparent on the face of the record, these review applications are not required to be entertained. We may also note that the application under section 340 of the Code of Criminal Procedure 1973 partly emanates 6 from an aspect which has been dealt with in our order passed today on the application for correction of the order filed by the Union of India. Stop.